It is such a pleasure for me to have all of you here. The entire colloquium is patterned for our own education and enlarging our own horizons. And today it's my pleasure to request Professor Joseph Sachs, who is from our Bolt Hall School of Law, to introduce our speaker.
Thanks, Professor Narasimhan. You know, when you're asked to introduce a distinguished lecturer, it presents a kind of dilemma for the person doing the introduction, because the more knowledgeable and informed and experienced the speaker is, obviously the more of interest he or she has to say. And at the same time, the more that is the case, the more there is to be said about the speaker. So I thought some about this and decided that it would be better to spend the time listening to what our speaker has to say about water than listening to what I have to say about the speaker. Therefore, I shall be extremely brief in a way that in no way reflects all that should and could be said. Justice Robie, Justice Ron Robie, who is our speaker, is a product of the Bay Area. He was born in Oakland and grew up there. He is a distinguished graduate of this university, both a bachelor and master's degree, and has his law degree from the McGeorge School of Law, where he is presently teaching. He has done just about everything, does and has done just about everything that is of interest in terms of the public resource management in this state. He was a judge in the municipal court, in the superior court, and is now a justice of the Court of Appeals in the 3rd Appellate District, which sits in Sacramento. He's a reporter for the Water Law Newsletter, for the Rocky Mountain Water Law Newsletter. He's a member of the Judicial Council, and I think he will probably want to say a few words about his own background as a government official and administrator. We have been looking forward for many months to his presence here and to his talk, and it is with the greatest pleasure that I introduce him, and we will have some time after the talk for some questions. So, Justice Robie, we welcome.
Thank you very much, Professor Sachs. It's a special pleasure to be introduced by Professor Sachs. He's sort of my idol. He didn't know that originally because he was way back in Michigan at the law school there when he wrote his major book on the public trust. And I have always done a lot of writing and thinking about the public trust and hopefully some implementing. And it's a great honor to have been introduced by you today, sir. The topic of my remarks today is California's water reflections from the bench. I really don't have too many from the bench because for the last 20 years I've been a judge and I've had very few water cases. I've had some, and I'll tell you about a couple of them, but most of what I'm going to talk to you about is what came before the bench, and that was my time in water. And so my subtitle for this topic is Water and the Environment, 1960 to 2002. And I'd like to talk about the theme that has really been sort of the permanent theme of my career, and that is relating the environment to water rights and relating water rights to the environment, more the latter than the former. And that's the theme I'm going to develop. And I guess the only virtue of being old is that you can tell stories that maybe some of you in the audience haven't heard because you're younger. And so I am going to talk about some of the things that happened in the early days that you may not know. It's nice to be back at Berkeley. I was here almost 50 years ago, and it scares me to think so. But it was in 1960 when I was studying for my master's degree in journalism, which is, as everybody has noted, I didn't do anything with except hang on the wall, that I saw a flyer on the wall of Dwinell Hall announcing that there was a Ford Foundation legislative internship at the California Assembly. And the Ford Foundation was anxious to upgrade the staffing of the legislature, which at the time was none. And the California legislature operated without staff. So I was accepted, and I went to Sacramento, and I applied for the education committee because I was sort of interested in education, and they said, fine, you can have the water committee. I went to work for the water committee and its chair, Carly Porter, from Compton, who was the just about the most prominent water person in the legislature, and people in those days pretty much specialized. It was an interesting switch for me since I knew nothing about water. I had been coddled by the East Bay Municipal Utility District for all my life. I turned on the tap and it was always there. But I came right in the middle of the 1960 election for the State Water Project, and my boss was the chair of that committee and the co-author of the Bond Act. So I ended up going to Sacramento, and I started what has become a 40-year career in all three branches of California government. So I do have a somewhat interesting perspective. 1960, as I said, when I came to the committee, was the year that California voters approved at the time the largest bond issue ever issued by a state, $1.75 billion. Believe me, it was large at the time. In fact, today we think of it as small money, I guess. That's something that gets lost in the budget crunch. But it was the largest in the history of any state. And that's particularly true because states didn't build water projects. Now, why didn't states build water projects? Well, at the time of this project, the major urban areas of California had been supplied water historically from the beginning of the century by large urban entities, either the city of Los Angeles, for example, the cities of the East Bay Municipal Utility District, San Francisco serving its adjacent cities, and ultimately the Metropolitan Water District in the late 20s serving the entire Southern California coastal plain. And so the urban areas got their water, but the agricultural areas relied on who? They relied on the federal government. The federal government was the primary water project developer in America for most of my lifetime. And in California in 1960, the federal government had just finished Friant Dam. It had other dams on the horizon, but there was a need for more water for Southern California, particularly since we were expecting to lose, and we did legally lose, although we haven't lost it yet, a major portion or big chunk of our Colorado River entitlement. And that was one of the catalysts. But the real catalyst for the State Water Project was to serve not only urban areas, but also to serve agriculture, and in so serving agriculture, to avoid the acreage limitation. I don't know how many of you even remember what the acreage limitation was, but the 160-acre limitation, limiting the amount of water that can be served to 160 acres, was stuck in the craw of the Californians because it was, except for the east side of the valley, it was an area where there were potential for many large farms, not just little small family farms. The acreage limitation had been fought bitterly over the years, and the acreage limitation did not get knocked out until amendments in very recent years, in the last few years, in which there were some modifications which have, I guess, pretty much quieted a lot of the discussion. But at the time, the State Water Project was desperately anxious to serve water to the Central Valley in order to meet, number one, the idea that it was a statewide project, that it wasn't simply another bigger than Los Angeles, bigger than MWD, bigger than San Francisco urban water project. And by tucking in large areas of the San Joaquin Valley for agriculture, it proved to be a statewide project. And the slogan in the 1960 election was one state. The idea that it was a group of projects or a group of service areas that were all over the state. Marin County, interestingly enough, didn't want in. They opted out. I had a great pleasure when I was Director of Water Resources in 1977, when they were struggling and couldn't get enough water, to put a temporary pipeline across the San Rafael Bridge and serve them with water. And I reminded them when we did that they were getting State Water Project water, which they had vehemently objected to. The same token, we served water to the city of San Francisco that year because they had a shortage of water. So the State Water Project has proven to be very versatile, and as I'll tell you in a minute, the fact that it has this statewide plumbing system has planted the seeds for some really creative things in water transfers if they can be done, if the will is there, the way is there, because the plumbing is in place. In any event, the State Water Project was approved by a very narrow margin in 1960. A couple interesting things about that you may not know. The State Water Project beneficiary that comes most to mind is the Metropolitan Water District. But did you know that they didn't even vote to endorse the bond issue until 5 days before the election? In typical water style in California, where everybody holds out until the very last minute for the very best deal, and many people get left at the station when they do that, MWD kept trying to wangle a better deal from the state, and they did not endorse the Bond Act until 5 days before the election. When they finally did, it was a little bit late. I don't think they really had that much influence on the election, but in any event, the vote was positive. Another interesting thing about for those of us who are used to having labor unions be great supporters of water projects, I can remember when we looked sideways at a water project once when I was director, having a room about this size with people pounding their hard hats on the table while I tried to speak, drowning me out because we were indicated opposition to a water project. At the time, in 1960, the principal opponent to the State Water Project was the California Labor Federation. Now, why was that? Well, because they didn't like the acreage limitation. That was the whole reason of being. And so we've had over the years some really sort of topsy-turvy alliances and things, and I'm going to talk a little bit about where some of those alliances have led us. In any event, in 1960, California was at the height of the development era. Pat Brown was the governor. He not only built water projects, but freeways and everything else. And that was the time when the planning and the original plans for things like BART were going through, and public works were the most important thing that was going on. Before I talk a little bit more about where we've been, I should tell you a little bit of truth in advertising, and that is I am a lawyer, and I understand, I think, some of the basic structure of California and water law, but I am an advocate to some extent in getting greater environmental considerations in water rights, and I have some law review articles suggesting such things from way back. And so the thrust of what I'm going to tell you is sort of, have we moved anywhere from where we were in 1960 in the last 40 years? Now, there are some fundamental problems with water in California. For a lawyer to talk like this to a bunch of engineers and other people, it's sort of maybe taking coals to Newcastle, but let's just go through some basic facts about California. Our water is mal-distributed. It rains and snows, first of all, in places where people aren't, and therefore the entire urban population is located in coastal plains with virtually no local water supplies, including groundwater. No groundwater in the East Bay area, none in San Francisco, some in the Los Angeles coastal plains. So we have put millions of people where there isn't any water. So that's what created the San Francisco system from Yosemite Park, the Alameda County system from the McAlamy, and the Colorado River Aqueduct, and the Owens Valley, which we'll talk about in a moment. Not only is that bad enough that we have water in the wrong place, we have the raw water in the wrong time, as everybody knows. Water flows unevenly during the year. As I was talking to Professor Sachs beforehand, California farmers are spoiled. They don't understand that farmers are used to having crops die because they don't get any rain in the summer. Well, we never get any rain in the summer. So California agriculture is almost entirely irrigated agriculture. There is almost no agriculture in California that isn't irrigated. And because the water is not where the farmers are either, in many cases, we have to have massive water transfers for agriculture as well. And therefore, the need for water storage and this huge plumbing system that's California. Now, the water rights that underlie all of this development. Water law historically was based solely on property rights. Water law is probably the most property right you can find. Almost every other property right has been subject to regulation of various kinds, and water has been the last to go. both pre- and post-1914 appropriative rights, which are the first-in-time, first-in-right rights, which were the important ones because they enabled you to store water and move it somewhere else and to store it so you could keep it from the winter and use it in the other times of year when you needed it. Those were subject to limited modification once you had put the water to what the Constitution refers to as reasonable and beneficial use. Now, an example about that. Mono Lake has lots of different angles to it. As you know, Mono Lake on the Eastern Sierra is saline and it's unusable for what we would call traditional beneficial uses, such as agriculture or urban water. But it is a great resource for fish, for wildlife, and some very unique little critters in the water. Mono Lake was fed by various streams that flowed into it. When Los Angeles, after the Owens Valley, needed more water, it went to the Mono Basin, and they diverted the water that normally flowed into Mono Lake. And hence, when we got past the 60s and into the 60s and years beyond, the lake was gradually getting smaller. It was going to be extremely destructive to wildlife, and the water rights were inviolate. In 1974, I was a member of the State Water Resources Control Board. And I remember very well attending a meeting where the water rights for diversions from the streams into the Mono Basin, into the Mono Lake, were before the board. Those water rights were granted in 1940 by a board that didn't put any restrictions virtually on them. That was the state engineer at the time. The state engineer granted the water rights, and all they had to be done is they had to put them to reasonable and beneficial use over the period of time allocated to put them to use. And they had placed the water fully to use. And I said, being a little nervous about it, before I vote to approve a license, which means you have a vested right. If anything, if you want it, you have to pay for it. If you want to take it away, it's a vested property right. I asked the chief counsel of the water board whether I had any discretion and whether I had to do this. And he said, no, you have no discretion. It's a ministerial act. It's a vested right. If you don't approve it, the court will issue a writ, which I now know what it was, and they will tell you to do it anyway because it's a ministerial act. And so I voted for it. So if you want something bad in my past, I helped out that. The fact was that water right was absolutely secure, and Los Angeles knew it until later on when it wasn't so secure. We'll talk about that in a minute. But that's a very dramatic example of how water rights were unavailable until things happened later on that nobody expected in those days. Riparian rights are even more inviolate, except you can lose them if you don't use them. But nobody knew where they were. They weren't recorded in California. And people could sort of bluster about their water rights. And they formed the basis of the first Los Angeles diversions. And this is the characteristic of riparian rights. Riparian rights are rights that accrue to the owner of the adjacent land on the stream. Who can object to a diversion under a riparian right? And you only can do it with a private lawsuit against somebody else. The only other person who could really complain about your diversion is another riparian on the stream. So if you take all the water upstream, a riparian downstream can say, wait a minute, I'm entitled to my correlative share of this water, I'll sue you, and we'll have to share. So that's what water rights, riparian rights are. They're sharing rights. They're only good, though, when the water's there, of course. It flows, you can't store it, and you have to take it when it's there. What did Los Angeles do? People have sort of forgotten this. They bought all the land adjacent to the Owens River. When they bought all the land, they said, we're taking it to Los Angeles. Who is available to litigate and sue them? Well, they're not going to sue themselves. There was nobody left. And that's how they took the water. They basically said, we're the riparian owners to this water, we'll take it. Riparian water normally can't be used off the premises. It can't be taken to Los Angeles, but it was because there was nobody else. So by surely using their force and their ability to buy the riparian rights, no public interest intervened, no state agency, no anybody. No court had any legal authority at the time to say that those rights couldn't be manipulated in the manner they were. And that's just an example. Those are sort of gross examples, but individual riparian rights anywhere else had the same characteristics. Groundwater is essentially unregulated. Groundwater has been the subject of lawsuits on and on and on. Recently, the Supreme Court decided maybe the last in the major lawsuits on the rights to groundwater. But it cries out after years and years of litigation, thousands of dollars of litigation, with still a court-made rule limited by the old water rights rules of the past and not with any public interest considerations at all. Many, many efforts have been made to bring more coherence to groundwater rights. And I might say as a little footnote that since being a judge for 20 years, I haven't been in the trenches like I was before. And there are things going on in the last 20 years that I may not mention in these remarks today. But basically, things haven't changed all that. In the South Coastal Plain, when the water intruded, seawater intruded underneath the basins, they did something about it. When things get bad, they do something about it. But there still is no coherent water rights management scheme for groundwater. The governor appointed a commission in 1978 headed by the former retired Chief Justice of California. It put out wonderful reports, great ideas, and very little got enacted. Water transfers are still difficult. They're easier now, but at the time they were absolutely impossible. Other than the big governmental transfers or the transfers affected by taking all the water from somebody and having nobody complain. So the idea of individual market factors influencing water going to the more economic use of the water, there was just nothing in 1960. A couple of the other things that are characteristic of California that are so obvious, but I want to mention them. California has periods of drought. You know, life is just wonderful when there isn't any drought. There's more than enough water for everybody. And everybody goes sailing along, and then all of a sudden drought comes and the wall comes up, and everybody starts panicking, and nobody is usually prepared. And that's when the system is stressed, and that's when the system doesn't perform. All of the protections that are built into the existing system are really not even needed in most of the above average years or average years. Then when you get to a dry year, that's when they're really needed. And somebody once said that having a protection that isn't enforced in the time of drought is like having an insurance policy that expires on the death of the insured. And that's exactly what we had. Dry years, we're having more and more dry years now because we've developed fewer new water supplies and we've got more people. But historically, the only time that the conflict really occurs is in dry years. And it was interesting in 76, when the first year of the drought, the State Water Project at that time was about 5 or 6 years old, and we were delivering water to everybody. Whether they asked us for water, we gave them whatever they wanted. They had lots of space in their contracts, and we had lots of water, and we just delivered it. 1976 was the 76, 77 drought were at the time the worst drought in history. And in 76, the question was, do we just drain all these reservoirs and give everybody all the water in 76? What about 77? And, you know, we don't know what 77 is going to bring. We had TV weathercasters that were telling us what to do, but we couldn't rely on that. The farmers in the San Joaquin Valley told me as Director of Water Resources that they wanted it now, and they would worry about next year. And I said to myself, well, next year, they're going to be blaming me when they don't have any water. And I said, and I called our engineers together, and I'm not an engineer. And I called the engineers together, and I said, how do we decide how much water to deliver? And they said, we deliver whatever they ask for. I said, well, you got to have a system engineers. You can figure out a curve. I didn't know what a curve was, but I said, you got to be able to come up with one. And they came up with a rule curve, and they said, assuming the possible years and what kind of runoff we would have, and assuming the amount of water we want, and we'll take a chance at 60%, 40%, and we developed a curve which is still used by the project, obviously. And we allocated water for 1976 and 1977 and the years beyond based upon an intentional theory of how to operate it. But everything was sort of casual. People didn't, the system just wasn't working. And the reason it wasn't working, it didn't have to work until the squeeze got put on. A few other facts about water from the environmental sides of things. First of all, in 1960, regulation of water quality, there was no water quality. It wasn't the word that had gotten out of the laboratories and into the governmental side of things. In 1951, regulation of water pollution in California was in the health department. And you know what the legislature did in 1951? They took it away from the health department and gave it to public boards consisting of basically polluters. And why did they do that? They said the public health department was too strict. The public health department was too strict. When I grew up in Oakland, there was raw sewage in the Oakland estuary when I went down to the play as a kid. So they created a board, a series of boards that had the polluters on it. The regional water quality boards of today, they have been changed. In 1959, they added a couple more. And it was not until the Porter-Cologne Act that public members were added. And they still are not. I don't think they're still a majority. But in any event, the regulation of water quality was designed to be not too tight to people. Don't squeeze people too much. And protection of water quality for recreational uses, fish and wildlife uses, and aesthetics was simply not part of the lexicon. My Friant Dam example is the best on how water rights did not consider environmental considerations. Friant Dam was built by the federal government. The water right permit was issued by the board. At the time, the Water Rights Board in 1959, I believe. At the time, it wiped out the entire salmon run in the San Joaquin River downstream from Friant Dam. The water, of course, from Friant went south by the Friant-Kern Canal, north the Madera Canal. And at that time, the principal standard in the law for granting a water right was the public interest. And the board made a specific finding, and I've sort of thrown it back to them ever since. They made a specific finding it was not in the public interest to protect the salmon in the San Joaquin River. It's only in the last couple years that small efforts have been made to provide test flows and things to restore the fisheries in the San Joaquin River. The San Joaquin River, at one time in history, was one of the major rivers of California. But it was completely wiped out by Friant Dam, and nobody really had any problem. And not only was there no problem, it was in the public interest. So that's an example of how water rights, when I came on the scene, were being taken care of. And limited consideration, of course, was given to in-stream uses in general. The other thing, the federal government did not have to comply in building all of these things with state water law. It appeared before the Water Rights Board, the Water Resources Control Board, as a matter of comity, which meant that if we don't like what you do, we don't have to pay any attention to it. Projects were frequently built not where the need was, but where congressional support was developed. New Melones is a good example of a dam that was built before anybody had any idea who was going to use the water. And that was common. Build the project and the users will come. I used to go back to Congress and talk to Biz Johnson. How's my little Auburn Dam coming, he would say. And I'd say, well, it's there, it's coming. You know, it hasn't come yet. But anyway, and water contracts for the State Water Project were actually politically allocated to some degree. There are a lot of allocations in the San Joaquin Valley for marginal farmland. The contracts were manipulated, and with the concurrence of the urban users, to make the water prices lower than they should have been, lower than they were promised to be, so they could get by and not go under initially. And of course, we all know that federal water supplies were always woefully underpriced because of giant subsidies. Well, most people who know me know that even though I sound gloomy at times and I wring my hands and I like to improve the world, that I am basically an optimist. And all during my time as Director of Water Resources, I was optimistic something would happen, positive, and we tried. And so I think there is some things that can be said about where we are today. When you begin a new diversion today, even though we have a lot of old ones that are already there and it takes time to go back and deal with, there are substantial considerations of environmental factors in water rights now. It's almost closing the barn after the horse is out, but it's still there. And that's largely because in the case of the Central Valley Project and the State Water Project, the State Water Rights Board reserved jurisdiction to coordinate the two projects in the Delta. And the Delta is 40% of the state's water. So by coordinating the projects, they said, well, we'll coordinate them by adding environmental conditions. And while the original intention of coordinating really didn't have that in mind, it does today. And so through the mechanism of the coordination reserved jurisdiction, those two major projects have had infused into them. The State Water Project actually probably would have had it anyway, but the CVP had infused into it environmental considerations that would never have been happened had it not been for the creative interpretation of the coordination reserved jurisdiction. In other words, in the Los Angeles water rights from the Owens Valley, they didn't reserve the jurisdiction to see if something later would come along. But because those two water projects operated in the Delta, and the feds operated as a rebel without having to do what the state wanted, they had to reserve it until they got some kind of agreement between the parties. And so there is environmental consideration based on water rights themselves in the Delta today. And then, of course, we have the National Environmental Policy Act in 1969. No matter how you slice it, the NEPA has made government agencies stop and take a look at the environment before they do something. Doesn't prevent them from doing something wrong, but it makes them stop and take a look. The California Environmental Quality Act of 1970 is even tougher in many ways and requires mitigation. We all know the law that has had the biggest impact, the Federal Endangered Species Act, interpreted over the years broadly to cover private activities beyond just the federal government. Pumping from the Delta is subject to the Endangered Species Act. There are endangered species in the Delta. And then, of course, and Professor Sachs, the first person who ever uttered the public trust doctrine other than Erie versus whatever, when I heard about it, when he was applying it to everything else, the National Audubon Society case versus Superior Court, the California Supreme Court's case of 1983, which truly has been a major impact in California, and actually resulted in a referral on the Mono Lake case. It grew out of Mono Lake. The public trust is theoretically a consideration in everything today. I was saying privately to people talking before we started that if the government agencies who are charged with implementing the law don't have the guts to make it work, that's the biggest problem, not the concept itself. And I think that's where we have to encourage people to have the will to make it meaningful and not to be afraid of what people might say if you do something important. The Central Valley Water Project Improvement Act, strong amendments to the Central Valley Project Act requiring dedication of water for in the environment, requiring renegotiation of contracts. I know there's been a lot of litigation on this, but it's still a significant fact. There were laws passed to encourage the use of reclaimed water. Unfortunately, California is still way behind on reclaimed water. There are some parks, there are some this, there are some that, but we could make a lot more use of reclaimed water in California, and it's been sort of a real problem, but the laws are there. And there are laws now in place to encourage water transfers, not only at the state level, but as part of the Central Valley Water Project Improvement Act. We do have water quality considerations and water rights now. The State Water Rights Board was merged with the Water Quality Control Board in 1967, and I'm proud to think that that was my idea. And it became the State Water Resources Control Board. It has the potential of making certain that both factors are considered fully in either of the when either subject comes up. The Port of Cologne Water Quality Control Act, which is the forerunner of the federal Act of 1972, now called the Clean Water Act, which does have significant water quality requirements which can be imposed on water projects indirectly. And finally, after long last, and we worked on it for so long, US versus California, where the Supreme Court said that the Reclamation Act meant what it said, and the state and federal government must work together, and the feds must comply with state water law unless otherwise required by law. And the coordinated operating agreement between the two parties was entered in the 80s, so the projects are now operated in a coordinated way. And to give you an example of how that didn't work, in 1977, during the drought, I was committed, as the law required, to meeting the dry year standards on the Delta in operating the state water project. In operating the state water project, we were committed to meeting the dry year standards. That required the release of water from storage, released water from dams in the middle of the drought, which would go out to sea, which would not go to Kern County Water Agency or wherever else it would go. And as a result, there was a certain number of acre feet, several 100,000 acre feet, that had to be released by the two projects in order to meet those requirements. The federal government said, we're not making our releases because we don't have to. And so they didn't. And so we released water to make up for the federal side. If you don't think that that caused strife with our water contractors, very, very serious problems. But we were obligated, I thought, legally to joint and severally meet these standards, and if one wouldn't do it, the other one had to. So we did meet those standards at the expense of a lot of water that the state water project contractors wanted for themselves. Now, under the coordinated operating agreement, the formulas are in place, and the projects, I think, generally speaking, are operating in a cooperative manner. That makes a big difference for water quality in the Delta, which is a major problem. It's always interesting for me to think about how over the years, when people have tried so hard to improve water quality in the Delta, the biggest objectors to all of this is the Delta, and they still file lawsuits endlessly over anything related to the Delta. It will be, and I think in many respects, what we have in California is a a small group, a cottage industry of water litigators who just litigate and litigate and litigate. It's a whole career, and I like very much Dan Nomalini from Stockton, and his son appeared before me in court the other day, and I saw, this was when I was at the trial court, and Dan was in the audience, and his son was arguing another Delta case, which I had. And afterwards, I talked to him. I said, well, your son did very well. You know, the tradition's going on. This litigation can go on another couple generations. And I didn't ask his son if he had any kids who were going into water law. My kid went into probate law, so my pitch is gone. But in any event, the whole thing is that I think we litigate much too much, and there are some, I think that people think that litigation solves problems, but it truly doesn't. And we inch forward toward better things. Well, some of the better things that have happened are Mono Lake. And it was interesting because there was a task force on Mono Lake when I was director of water resources. And at that time, Jimmy Carter was president, and the federal representative voted with the state people to reduce Los Angeles's water diversions to protect the lake. The only vote, of course, against it was the city of Los Angeles. So here was a major federal state task force said to do something about it. Los Angeles didn't budge. It did budge later. The public trust was applied. Lawsuits, lawsuits, lawsuits. Enormous public campaigns. The Mono Lake Committee and other people, you've never seen an environmental campaign like that. It's a shame that things can't be done the way they should be done without that kind of effort. Los Angeles now is putting water back in the Owens Valley. I don't think anybody ever dreamed they'd ever do that. Once again, to this novel theory that when you dry a lake bed and the lake bed forms dust, it goes up and causes air pollution, and so Los Angeles is in violation of the air pollution laws. They're putting water on the ground. They're not creating a lake, but they're trying to put water on the ground to create less of a dust problem, which in turn will provide some vegetation and perhaps some wildlife, and once again make a difference over that riparian water transfer that nobody had anything to say about. I don't know if you can say anything about the CalFed process. Come back in a couple years, the same thing will probably apply, but there is a process to try to work people together to cooperatively come to solutions to the Delta in the long term, including some more storage. But as I said, it's something that's going to be a long time. The East Bay Municipal Utility District, they negotiated a contract for water from Folsom South Canal when I was on the water board. We established minimum flows in the American River, but the diversion would have taken water out of the American River upstream from where those flows were. And it was creating even though the minimum flows were there was going to be a long-term conflict between the diversion, which was upstream from the American River coming through Sacramento. That's been renegotiated now, and as a result, the diversion's going from somewhere else. And that, after long major study, and of course there was a big lawsuit involved in that too. You have to have a lawsuit as part of the process. Water transfers. I have an interesting story about water project transfers because it came in my courtroom. Doherty Valley here in Contra Costa County development, the East Bay Mud said, we don't have any water for you. We can't supply you with water because we don't have any. So they said, fine, we'll go to Kern County. And they did. And they went to Kern County where these contractors that got state water that really didn't need it are now ready to sell it. And they sold, Berenda Mesa, Kern County Water Agency sold water to basically the Livermore people to be transferred to Doherty Valley. And they brought it through the Alameda County Water District, and they did something very creative. They used the groundwater basin as the transfer. They said, we're going to, now, the State Water Project provided the means for doing this. The water didn't go down to Kern County and come back. It just stopped off in Alameda County on the way to Kern County. And then when it did, it got delivered, and that's a water transfer. And that's what the system is wonderful in that. The only problem with the deal was there was a certain amount of water, like 10,000 acre feet. The contract was for 10,000 acre feet coming in, 10,000 going out. Problem was the 10,000 coming in was subject to shortage by the State Water Project. The 10,000 going out was uniform year round. And they said, wait a minute, something's happening in the water basin. It's not balanced. And so I ended up ruling it was not legal. And then there was an environmental challenge, and I ruled against them. So we had, both sides got rulings against them. And I encouraged them to go to a mediation and try to resolve this. And they did, and they went with a retired judge and 17 or 18 lawyers. I mean, they always come, 18 at a time. And it was the most astonishing experience because they selected as their chief negotiator and the spokesman for all these water agencies, Tony Rossman, one of the best environmental lawyers in town. And Tony and the group negotiated, along with the judge, a settlement outside the box. They came up with things that the parties got that they couldn't have gotten in the lawsuit alone, because a lawsuit was limited to the issues before the court. They solved it all. Everybody went away happy, and I think it was one of the best solutions that they could have possibly done. They never could have done it by litigation, but they never would have done it by negotiating without litigation. So there it is. So that was a very creative water transfer. There also is some groundwater storage now in the Kern River water bank, for example, and other places. Final couple thoughts about things. I was just reading an article in the paper about politics. I don't know if you saw the article that said that the coastal people are Democrats and the mountain people or valley people are Republicans. Well, that's not what I want to talk about. For years, water people hung together even when their interests weren't the same. In other words, if the farmers had a bitch about water, the urban people joined them and agreed with them and defended them. Now what's happened is the urban water users have finally found that their principal interest is with the urban water users of the state. And now we have the urban water users saying everything the agriculture wants or the farmers want is not necessarily in our best interest. And so now we're getting an alignment of water interests along the urban versus agricultural. Now, this can't be a destructive kind of alignment, but it makes more sense. There's no reason why in 1982, when the state of California Department of Water Resources said you're wasting water in the Imperial Valley, that the Metropolitan Water District said, no, they're not. When the Metropolitan Water District would have been the principal beneficiary of a transfer, which is now maybe coming to fruition. MWD at the time said, oh, no, our brethren out there, we don't dare offend them. They're doing just fine, and they knew darn well. And when the director, when their assistant director, who became my successor, said, this is not in our best interest to do this, it made me want to just scream. So the point is that the urban users are now deciding that maybe they should stick together and they're not just going to go ahead with whatever other sides want to do. One of the big surprises that you may not think about, everybody expected when Ronald Reagan was elected president that this would be the high point of water development in America because he gave more support than the Democrats who might have been environmental. And you know what? He was the stingiest president in history on water projects. He imposed cost sharing on Corps of Engineers projects, and literally since his time, very few federal water projects have been built. Go back and look at them. See how many federal water projects have been built since 1980. The economic times, the budget cuts of the Reagan years, people were in this fat period of time leading up to the 60s, through the 70s. And they just thought people had money to do anything. And so it's amazing. And we are being squeezed now in the year 2002 because nothing has happened in the last 20 years. Everything has had to happen on using, in other words, people have been forced to use what they had more effectively and more creatively because you don't have any new stuff. State Water Project still does not have its full contract yield. It's still at 2 point something rather million acre feet when it committed to deliver 5.4. That's what's criticized a lot in the past, but it would have been a terrible thing to do it otherwise. But now there's a real squeeze on, and the urban water users, particularly who contract from the state, are going to have to make major efforts to get that water in a different way, and they're doing things. They're building terminal storage in Southern California. They built Los Vaqueros here. There's lots of things that have been going on. Well, we don't have a true water market, but we should have more of one. And finally, water conservation. Agricultural water conservation, as the price of water increased, has been an influence. But I think there still could be a lot more done about water conservation. Water conservation in urban areas is a sometime thing. If there's lots of water, nobody does it. And so we have to retrain each generation when things get short that water conservation is an important factor. But it's an important element in future water management. Water reclamation, water management, groundwater regulation, groundwater storage, urban water, transfers of water from one area to another, from one use to another, equitably, and inclusion of environmental considerations in water rights, however they are established or transferred. Now, I didn't pay attention to the time, but I think you've just about exhausted my time.
No. If you have time to take some questions.
Oh, of course. I do have time for questions, but then I don't have to say anything. You can say something. Yeah.
You were mentioning that the Water Resources Control Board has been very cautious, to be polite, about the public trust doctrine. And that's supposed to be nominally independent, but it never is. I mean, in my experience, they've always been very deferential towards whoever was governor. Are there any structural changes that could be made to that board to make it more willing to make some tough rulings?
Well, I think that people are people wherever they are, and I don't. I think you have an executive. I think the executive branch is the executive branch. The judicial branch has some independence, but some people would say not enough. And I think that the public. I think there are some tough decisions that have to be made about the public trust, and I think ultimately they will be made. But I don't think that tinkering with the government structure really solves the problem. I think the legal principles are there, and I think they can be effectively implemented. I think they've been somewhat timid.
I just had a question about the water transfer. We talked about Third County and the Dorsey Valley. The logic of it, presumably we give permits for water users. The Third County people got a permit to use the water for some specific purpose for some duration of time.
Well, no, they actually didn't, and that's the difference. The state and federal projects got permits that went to the project, and that's the way the federal projects operate too. The Central Valley Project gets a water right, and their service area includes all those areas. So when the actual water right for the State Water Project says service area, Alameda County, Kern County, Tulare County, Kings County, Los Angeles, San Diego, etc. So the project operator can move the water around anywhere.
operator moves. So out of this transfer, some folks in Kern County agreed to transfer the water to Doherty Valley for some price. And so it essentially, if it goes on indefinitely for a very long period without any time limit, it essentially implies that the Kern County folks own the water and then they are selling it forever, which is fundamentally against the public trust doctrine that it is the people that own the water and that they are giving the rights to use specifically for some people or some groups of people, regardless of how the contractual arrangement has been set up through the state water project or central water project.
Oh, I think that well, I think that certainly logically follows that that if any water rights should be subject to later revision, so should one of these. And I think that the state water project is subject to the public trust in its permits for whatever. So I think that's one of the unusual things about water rights in California. I should have mentioned it, I suppose, it's one of my initial thoughts. And that is that because we have these massive projects, we don't deal like they do in Wyoming on Project A, Project B, all these little dinky projects. When you talk to law professors from other states, they're always talking about the farmer here getting this and the farmer there. But here, you get, 2/3 of the state is covered by 2 water right permits. So what we're doing is manipulating in between them. I think that's true. And I think the reality of it is that Brenda Mesa is giving up that water forever as a practical matter. The people in Contra Costa County are going to be using it.
But that essentially becomes that somebody owns the water and sells it for profit.
Well, yeah, but I think what's going to happen is that if the state water project gets scrunched because it doesn't have enough water, the Kern County water can still be transferred by the state to Los Angeles. So Brenda Mesa may not have anything left to sell. So you still have that potential.
But that is okay because the state acts as a trustee for the public.
Right, right. That's correct. And the Department of Water Resources in this lawsuit sort of sat around and I said, what is your position? We're watching. So they had to sign off on it though, but they didn't take a side. And I can talk about this lawsuit because it's all final, but they didn't have a formal position, but they had to sign off before, because they had to agree to a contract amendment by Brenda Mesa to use the water somewhere else.
Following up on that, right now the water contractors with CBP and the state project have contracts.
Right.
Did I understand correctly that Senator Feinstein was proposing to turn those into water rights? About that?
I'm not familiar with it. I think that the federal cases, and I'm not an expert on federal law, but Professor Saxon probably knows, federal cases talked about water districts having a water right, but I don't think they technically did. I think the right, the only right is derivative from the federal right. They had a contract right. They didn't have a legal right. Cognizable under California water rights law. Well, she can't do anything. I don't think she can do anything with California water law. I think anybody who dabbles in water law has got she'll have to serve a couple more terms to get anything done. I mean, it just takes a long time to do anything, whatever she's doing.
Quick comment on the repair of the Hetchichi system, the bond issue in San Francisco. It seems to me that there should be some reserve fund like condominiums have for a long time.
I don't know anything about it. All I know is that the system has to be secure. It's there. There are a lot of people who don't want it there, but it's there, and you have to have a secure system and a reliable water supply for a huge number of people. I mean, people think of San Francisco, but you should think about Santa Clara County and the San Mateo County and the whole peninsula. So I don't get involved in that. That's the last thing I do. But I don't know. But I just think that you have to have a secure system, and I'm a little surprised that San Francisco has permitted anything to get run down like that, if that's true.
I was interested in your comment about the need for a true water market. I wonder if you could look in your crystal ball and look out 20 years from now and give us your view of what's to come.
I think we'll just be continuing to make gradual progress, because I think what's happened is I think the shoe is tightening, the shoe's tightening, that we're not going to get lots of major new developments. I mean, I was director of water resources from 75 to 83. We talked about enlarging Shasta. We talked about Los Vaqueros and other things. You got Los Vaqueros, but you don't have anything else. we're going to be really pressed in 20 years to make use of what we have. And I notice now that MWD is giving a contract for some desalting somewhere down in the district. But when I was director, they had a big plan for a combination nuclear plant, desalting plant, right offshore of Orange County. Well, nuclear plants went away, but the desalting idea was supposed to be a big then. So I think those will continue to come. The people who want to bring things down by plastic bags are still there. But I think that we're going to, I think that it's going to get tougher, but I think we're still going to stay within more traditional sources. But I don't know. It moves slowly. And I'll be interested, if you all come 2 months from now, see what Tom Graff says about this, because he was one of the people who, I agreed with on a lot of things, but he had an awful lot of monkey wrenches in his...
Yeah, I'm thinking that as these things get tighter and tighter, there's more rights than there is water.
Right.
And then there are these absurd disconnects, for example, between groundwater and surface water. And it becomes incredibly expensive and politically indefensible to maintain these ecological disconnects and the right-spaced approach. Wouldn't there be more hope in taking a look and seeing what the public interest might be in some of these marginal cases?
Well, you mean having the courts do it?
Well,
that's the only one that...
No. I mean, that's the thing that everybody says. Yeah, well, you know, you have these stakeholder negotiations going on now all over the place, but most of the stakeholders involved don't even know about the protection, the history of protection of public rights, or even that public rights have played a role in water. And I'm just thinking with greater public education, perhaps, people might expect their administrative agencies to act within the legal framework.
Well, I think when I'm not sure what your question is, but if you have, I'm an optimist, I said, and I thought in 1978 we might be able to get some groundwater legislation. I think that the dilemma of using groundwater in an integrated manner and really making a creative use of it is going to come by legislation at some point. I do, under the legal system that we live in, I'm not here to say property rights go out the window. I'm just saying that water rights can be regulated, should be regulated in a manner that other kinds of property rights are regulated, because we still have jurisprudence involving takings, and I'm not suggesting that you can just go around taking people's rights. You know, we still have very, very important legal principles that we can't just run roughshod over people's property.
But those are just recently created. I mean, you get a situation in the climate where the government, you know, the federal government has made promises to people with red skin and to people with white skin, and all of a sudden the promises to people with white skin mean something.
Well, I don't want to get involved in specific issues now, Penny, because I don't know what they mean. But I think that ultimately you're going to have to work through the system. You're going to have to modify the system to make it work better. That's what has been happening all along. Los Angeles was able to adjust to the public trust doctrine without losing its shirt. They still are there, and they're going to be able to do it in both the Owens Valley and the Mono Basin. Other people are going to be able to do it. You're going to be able to work within the existing system. That's why I think that you can't just tear the whole thing down. You have to work within it and make it go. But it takes a long time. So you could have such a lecture 40 years from now and talk about, well, now where are we?
Well, let me make the same point, maybe in a slightly different way. First of all, it seems to me that for water markets, an absence of groundwater regulation is an invitation for disaster. That is, under the existing system, there are natural limits to groundwater overdraft because how much water is a farmer going to use? But if you can sell groundwater, then there's an infinite demand. So essentially no limit to the amount of water that can be extracted. And so it seems to me having no regulatory framework for groundwater becomes counterproductive because it either means everything is frozen, or it means, I think, serious, potentially really serious overdraft. The other issue...
Well, just one second. I think, though, that you still have the constitutional provision against unreasonable use, method of diversion, method of use. You have to use the courts to enforce it, but you wouldn't let something go that far.
But one man's unreasonable. I'm not a lawyer.
No, I don't think so.
What exactly... I never understood how you would recognize unreasonable use if you tripped over it in broad daylight.
Well, that's true. I mean, there's merit to that thought. But, you know, if the groundwater basin is going to be destroyed, which is what you said originally.
Well, I'm sorry, destroyed. But you know, you can lower the water table and raise pumping costs, but there's still molecules of water. I mean, it seems to me an invitation to troubles to open up markets in groundwater and have no regulatory framework. But I also want to mention, getting back to the state board, there's the issue of the environmental impacts of water transfers, because they change flows and streams, they change the timing and so on. And again, in an ideal world, you would decide on guidelines, you decide on in-stream flow protection ahead of time, and then that creates a framework in which water transfers can occur. But right now, the board does things piecemeal. It doesn't, it could, if it woke up one morning and felt like doing this, decide to have a hearing process which would enunciate rules for in-stream flows and restrictions and so on. But being proactive and waiting until somebody sues somebody before means that there are no known rules.
Well, the water board does have authority over water transfers to the extent that the state laws grant the board authority over water transfers, but I say a lot of the transfers are going to take place within the state water project, but the water board has authority over the state water project.
No,
so
my point is, this gets back to the question of the state water board, the combination of two things. Having narrow vision and being completely proactive, and waiting until somebody initiates a lawsuit. And secondly, acting under the governor's thumb, and therefore being unwilling to make a decision until the governor tells it. And these two things go together, because any government would rather have no decisions than
well, no, I don't think that's true. I think you're being a little too harsh about the whole thing. I think that you know, you have to understand that regulatory bodies don't go around inventing problems to solve. They deal with, and I guess I'm still a lawyer and a sort of a traditionalist, but they deal with the issues that come before them, just like courts do. And if somebody has a water transfer that is subject to the law and they announce it, and they offer a chance for protest, and Fish and Game is right there. When I was Director of Water Resources, Fish and Game had 0 lawyers. They now have 27. They've got a whole legal staff that's one of their functions is to deal with protecting the fishery resources in the water rights context, among other things. So I think that there's I think you still have to realize that we still have a system, and things don't just happen, you know, automatically. You have to have, there's a forum for these things. Some people think the board is timid. I think that the board needs to attack that in the Delamore because, but I think that that's a matter of judgment, and I don't think that you should generalize about it because I think the water board was there on the Mona Lake case. The water board's there, been on there a lot of things, and I don't think you can personalize it and limit it to just the people at one point in time. I think what we're talking about is we need some better laws. We need people to try to work together more, and I really do believe people should rely less on litigation. But at times, that's the only way to do it. Yeah.
It seems like through litigation, they're really fighting over crumbs. I mean, if you look at some of the projections, the state of California is supposed to grow by 25 million in the next 40 years. And so when you talk about water transfer, you're talking about taking water from something to put it somewhere else. And if you're taking it away from agriculture, or you're giving back the over-allocated amount California's been using in the Imperial Valley and letting that land go to fallow, it can no longer be used for agriculture. So there isn't any growing going on. So I guess my question is, I know that there's plans for off-stream storage in the state water project that could take 5 to 10 years to actually fill with the existing water budget. But are there any plans to look for new sources of water outside of the existing basins and tributaries and dam storage?
Well, see, let me just say my basic premise is that I think that we have to live with the whatever we have. I would hope that there would be some more supplies developed, but transfers from one area to another may indeed limit the activity where it came from and at the expense, so that another area can have it. But I don't think that's necessarily bad. It may not necessarily be bad. But I think, there have been, I mentioned the water bags. I mentioned, years ago, the head of the Department of Water and Power said they were going to go to Wyoming. I think it's preposterous now to talk about Canada and Wyoming and big water transfer projects when we can't put one together in California. So I just think those are those are no longer viable alternatives, or at least in the immediate future. And I think that desalting is, when you desalt seawater, you use a lot of energy, and and there are natural resources involved in generating electricity, and so. We know we have the science. Guantanamo's still running on recycled water. I mean, on desalted seawater. But I think we have to accept the fact of where we are, and I think we also have to accept that the projections of growth. We talked about them earlier, and everybody said we were going to be in a total disaster by 2002, and we managed to muddle through. So I think that people. It just bothers me that it has to get so bad that there's no other alternative but to cooperate before you do it.
Judge Robie, being in the water utility area, I'm more concerned about water quality
right.
Out to 10 or 12 years, 20 years from now. And I wonder when people use water, they use it, they generally degrade it and send it on somehow in a general term.
Correct.
Do you see any development of legal and market responsibilities to send that water on in better shape? Clean, deep major use?
Well, there are a couple different, I don't know, there are a couple different things. In terms of urban water treatment, the federal water law has greatly upgraded what people discharge. A lot of our big discharges in California are into the ocean, so they're going to be gone unless they're used beneficially on the land or something. They're just going to the ocean. The biggest problem in water quality today, I think, is those areas where streams are degraded by non-point sources, by land development, by efforts on the land that cause the streams to be degraded. In the mountain counties particularly, a lot of that water gets into the system that serves other people. But those non-point sources have never been adequately dealt with. The Federal Water Pollution Control Act in 1972 contemplated a planning process to do it. Once again, there was no specific implementation, like telling an industry you have to put a gadget on the end of your pipe. So I just don't think that, I'm not sure what is, I think water quality is, I don't know what's going to be done. I think that we've sort of reached the point now where we've squeezed a lot of good stuff out of urban users, but we're going to have to do more in terms of the ocean discharges, but that's about it.
Let me just make one additional comment. A major city that we serve, that I won't mention the name, but they have a storm drain system.
Right.
And basically they have over 3,500 28-foot wells, and they let the storm water run down into the aquifer just to get rid of it. And they're actually recharging the aquifer with rather dirty water. But they don't have the money, or they feel they don't, to meet these problems.
I hadn't heard about that, but water, storm drains are the non-point sources that some of them that we're talking about. A lot of the urban stuff is just, stuff running off streets and things, which is not good. But before storm waters are placed in the underground, they should be of quality. They wouldn't degrade the underground.
More frequent.
I'm a little surprised about that. I think that's, I don't know anything about it, but it doesn't sound good. I think we've taken about all the time.
We've kept you up there for
a
long time.
All right.
Is there anybody who has an urgent question?
No.
Thank you so much.